Ulrich?
Yeah, that's first floor.
Okay, so welcome to the second session of our conference on legal challenges to terror. Maybe that's because of the two microphones. We have three very interesting, promising papers, and I'll introduce each of the speakers in his turn, or her turn. Just two remarks, preliminary remarks, that actually refer to some of the stuff that came up in the first session and in the keynote speech of Ami Ayalon. You know, legal challenge of terror to the rule of law are a timely topic, not only in the Israeli context, in which we live with terror for the last 100 years, as Ami Ayalon said, but also worldwide. 2016 was a record year of terror activities, both worldwide and in Europe. 2017 was a little bit decrease of number of terror activities and fatalities, but terror, counter-terror law, how to deal with terrorism from a legal perspective is an issue that is now, I think, characterize most of the world, and especially the liberal democratic world. And one of the things that is quite interesting in respect of the remark of Ulrich Beuys earlier is the different discourses. If we compare the British and the French discourse, the French discourse was, as you described, a state of exception. We have a specific wave of terrorism. We operate Article 16 of the French Constitution, which basically entitles the president for unlimited powers. And this is a temporary thing, while the British discourse was very different. We have to change normality. We have to change the balance between human rights and security, not for a certain period, but for the long run. And what is interesting to see is that the last year in France, there is actually a shift from the state of exception, which ended, you know, and new initiatives, which makes a new normality. So the question whether, you know, this distinction of a very sharp distinction between normality and a state of exception or emergency is still a viable concept or framework is in itself an issue. And I think that some of the papers, Stefan's paper about declaring emergency and Stefan Vogt, yeah, and Laila's paper about the Israeli transformation, because we also have a new counterterrorism law. The old law was supposed to be enforced only when declaration of emergency exists. Unfortunately, we have declaration of emergency that exists from 1948 until today. But the new counterterrorism law is a permanent legislation. So we see this shift everywhere from this distinction between emergency and normality to a new normality, and this is quite interesting. And I think from a normative perspective, the question whether terrorism merits new normality or whether it merits a declaration of emergency is also an interesting question, because terror can be on various scales, on a very, very low scale of stabbing or cars running a pedestrian, or mega scale. This is the first remark. The second remark is that, you know, in my previous questions, in the previous panel, I talked about what is terrorism, which is, of course, a very interesting question. And we define terrorism in a democratic liberal way as a criminal offense that exists already, but is conducted with a special intent, which we usually don't use in criminal law. But this is not a universal phenomenon. When we look at, for example, the Russian definition of terrorism, Russian definition of terrorism is not based on existing criminal offense. It's any activity that is meant to subvert the political circles or the political establishment. So it's a much wider definition, which of course is prone to political manipulation. I think even in Germany, you don't have exact definition of what is terrorism, which is quite an interesting fact in itself. So I think that all these questions are quite relevant in the context of the papers and in the context of the session of the challenges of terror to the rule of law. So our first speaker is Professor Stefan Otter. He's one of the principal investigators of the Minerva Center. He's a professor at the Law Faculty of the University of Hamburg for German and Comparative Public Law and Public International Law. His past titles and occupations are very long. Maybe I'll mention that he's a member of the Permanent Court of Arbitration and member of the German Commission for the Geneva Red Cross Conventions. And he will talk about terrorism laws and armed conflict and war crimes prosecution, which exactly fits some of the ending remarks of the last session, the distances or the boundaries between war and terrorism. Stefan, the floor is yours.
Yes, thanks a lot for the invitation to speak here. And let's say in starting, I would kind of like to sketch out some more broad questions which drive me, because I'm in the last years I've tried to deal with terrorism also, let's say, beyond the pure legal questions, and just very briefly, the first problem which drives me is this question: how to understand the practice of terrorism, and if you model it in economic and analysis terms, it's quite clear it's not personal wealth maximization, or in a very kind of abstract sense, personal wealth maximization, which is then on an individual level what drives terrorists. And the second problem is how does anti-terrorism legislation and counter-terrorism policies in general influence societies? And what we know is that there's a strong symbolic element. You can see that in the criminal law exercise, that in the criminal law part, that often if there's a terrorist incident, the first reaction of politicians is we should raise the sentences in the criminal statute on that, where it's often doubtful, does that change anything in reality? But there is this strong symbolic element in it, which should not be underestimated. It's for the political dynamics important. But the other question is traditional counterterrorism really effective in the sense really to create incentives to lower terrorist activities? And as far as the definition is concerned, I here use a definition from economic authors, but this converges more or less with what Ami Alon mentioned earlier. There is a kind of core consensus on what terrorism means. There have been, meanwhile, one can say decade-long debates in the United Nations, and one of the committees of the General Assembly on a comprehensive anti-terrorism convention, and there is more or less a consensus on what terrorism is. There are the two political stumbling blocks: war of national liberation and the question of state terrorism, which prevents the consensus of working out a final document. And this definition, which has as a core element the violence against non-combatants, and for a political or social objective, and the violence used for intimidation of a large audience, kind of pressing politics and public into some political action. What interests me to a large degree is the kind of the interaction. It's a strategic interaction between terrorist strategies and on the one hand, and anti-terrorism policies by governments and security forces on the other hand. And if one, and that's my second introductory remark, if one maps a bit what are the strategies in dealing with terrorism, and I will come to the focus will be a very specific part of that, but just briefly, if you map the modes of societal and governmental reaction, I would say the first is strengthening security and intelligence services, and one should not underestimate the importance of intelligence services in that regard, enlarging their competences, improving their resources and organization, and a bit of the discussion we've had in Germany in the last 2 years, because we had this one incident of a kind of lonesome wolf driving a truck into the Christmas market in Berlin. And this was clearly a kind of disorganization of the security and intelligence services. It could have been prevented from the hindsight, but there was an element of disorganization in the structures. So that's one important element. Then it's clearly the criminal law and law enforcement part, with a common tendency to threaten higher sentences, to create new types of criminal acts, going more and more in the preparatory stages of terrorism. One of the most important parts of that is now the crime of being membership to a terrorist organization, and most of the foreign fighters coming back are prosecuted on that basis, because it's often quite difficult to prove in criminal proceedings what they have really done. Proving their membership in a terrorist organization often is relatively easy, because they, in all the social media, they are so proud of what they are doing that there's a lot of things which you can wiretap or retrieve, and that's in comparison relatively easy. One must say the criminal law track is practically ineffective in influencing active terrorists. It's mostly directed towards society in general, and to kind of try to separate active terrorists from their sympathizing background environment, creating disincentives for people of dealing too intensely supporting terrorists. There it might work to a certain degree. Now, the specific focus is on fight against international terrorism, which means lowering the marginal cost of terrorist activities, in particular if they have a safe haven in another state, which safe haven in another state, mostly in fragile or failed states, means there is no real risk of criminal prosecution, because they are beyond traditional criminal prosecution. They are outside jurisdiction of the target states, and there are no local authorities which could cooperate in criminal and police cooperation. One strand is, again, international cooperation of security and intelligence services. That's mostly beyond the law. We don't have that much of law on that. It's international cooperation in criminal matters, which is a highly legalized field, which also means it's a very cumbersome field and often very ineffective. There are two other, I would say in general, there are two rather different modes of fighting international terrorism. The first avenue, this cumbersome way of criminal prosecution and judicial cooperation in criminal matters. And the second avenue, military operations against terrorist organizations and its operational basis. I would say the first mode of reaction has been the routine pattern of all the international treaties on fighting terrorism during the last decades. And we have had quite a number of these treaties. They are all on this track. And the second track constitutes the kind of the option, the 9/11, post 9/11 option, which is not a purely US issue, because that's in Israel, you know it. You must use more or less the same tool Turkey has done it traditionally against PKK, going against them also outside their own territory. India does that in the Kashmir case. There are extraterritorial operations in Pakistan from time to time. And so the US is not the only state of doing that. With that, I'm at the war on terror paradigm. European international lawyers don't like the war on terror paradigm because it's in a way a circular type of argument. As soon as we send our military forces abroad in order to going against terrorists, this constitutes an armed conflict, and we have all the legal tools of armed conflict, which is really a kind of circular argument. And it's also what Ami Ayalon mentioned, the time frame, because it creates an indefinite time frame. The war on terror will never end, which means for detainees, for example, what does it mean? There's no end of the conflict, so they may be kept indefinitely. There are a lot of problems linked with that war on terror paradigm. But, and this is a very big but, as an international lawyer, one must recognize that this kind of military fighting against transnational terrorism abroad often happens in already existing law of armed conflict situations, which means even if you forget about this explicit war on terror paradigm of the US administration, you end up in this constellation quite often in the application of the law of armed conflict. And there's a logic in behind, because let's say armed conflicts often go along with this situation of fragile or failed statehood, and these are the situations where organizations like Al-Qaeda, and all their offsprings and relatives have a positive nurturing ground where they can find safe haven, where they can find some breathing space. With the result that most of these kind of strongholds of these transnational terrorist groups are embedded in situations of non-international armed conflict, and most of the operations taking place, they are not in itself armed conflicts, but since they take place in situations which are already armed conflicts in itself, they take place in a law of armed conflict situation. I only mentioned the cases of Somalia, Afghanistan, Iraq, Syria, Yemen, Mali, and if you take that list, a part of that, even the German armed forces in its relatively small scale military operations abroad, they mostly operate in these contexts of non-international armed conflict on the side of the government against transnational terrorist organizations. If you take Afghanistan, still the biggest one, now at the moment the biggest one is in size of forces is Mali, which again has Al-Qaeda in Maghreb as a background in coalition with local groups, but also the training mission in northern Iraq, which is the third important one, with its original intent against ISIL, belongs in the same context. So the consequences: transfrontier military operations against terrorist groups often happen to be governed by rules of non-international armed conflict, even outside even if you don't follow an explicit war on terror paradigm, you end up in the application of law of armed conflict in most of these situations. Politics often likes, let's say, at least the US has developed the law on war on terror paradigm because they wanted to make instrumental use of the broader legal competences, broader legal possibilities of the law of armed conflict paradigm. Not all governments like that. You had this experience of the German government denying for some years that Afghanistan is at least the German armed forces operating in Afghanistan in an armed conflict situation, but that had purely internal policy reasons and was in a way endangering the armed forces because it was curtailing their operations. If you say they are not operating in an armed conflict, it means they we had this saying of the arms bound behind the back. It was a bit that type of situation. But in general, let's say politics of the states operating these anti-terrorist struggle by the military abroad, they like the law of armed conflict, and they like it because the terrorist organizations then become legitimate military objectives, which allows a shoot-to-kill policy. Even if you're in a non-international armed conflict, there will usually be direct participation in hostilities, which is here abbreviated as DPH. If they participate directly in hostilities, they are legitimate military targets, and the so-called membership approach, which was the Agana doctrine of the US, has been largely accepted by now, which means a kind of a constant professional member of a terrorist organization is in itself, like a combatant in international armed conflict, a legitimate military objective. This justifies to a certain degree also targeted killings. We just had in the break a discussion on that. There's no proportionality issue on going against enemy fighters which are involved in directly participating in hostilities. The proportionality question comes up with the collateral damages, which are a usual accompanying effect of targeted killing, at least if they are done by precision-guided munitions from drones. Then you often or regularly have a collateral damage question. This is the one side, the one major result if you operate in a law of armed conflict paradigm. The other consequence, and that's the second major part of what I wanted to present here. That's also why there's a certain preference for the law of armed conflict paradigm, because there's a relatively clear boundary. What are legal modes of fighting and what are criminal modes of fighting? That's in the law of armed conflict quite clear. Even a non-international armed conflict, abbreviated here as NIAC, because terror attacks targeted deliberately against the civilian population, they are clearly outlawed in law of armed conflict, constituting war crimes, which means terrorist tactics, which are quite often in hybrid or asymmetric warfare, are clearly outlawed by the law of armed conflict, which means the law of armed conflict paradigm thus not only allows for robust use of force in military counter-terror operations, but it corroborates at the same time the normative asymmetry between state organs and non-state armed groups, at least if they use terrorist tactics, because also the non-state actors in principle are bound by the fundamental rules of, I talk here on non-international armed conflict, by the fundamental rules of Common Article 3 of the Geneva Conventions, which call for respect of the rights of civilians, fighters, hors de combat, and targeting these protected persons is clearly outlawed under humanitarian law with individual criminal liability. This individual criminal liability was for a long time problematic under the regime of non-international armed conflict. They were not falling under the grave breaches regime of the Geneva Conventions, and thus there was no universality of prosecution against these. But well, I think I leave aside the national liberation movement's case, because that's a very special case. I continue here with a third indent on this slide. There was a discussion on national liberation movements already in the 1970s at the Geneva Conference, which created the additional protocols to the Geneva Conventions. It was very heavily disputed, but there was an attempt to bring that under the paradigm of international armed conflict, and one can say in a parallel move during the 1990s, the result of bringing them under the war crimes regime was achieved also for serious violations against fundamental rules of international humanitarian law in non-international armed conflict. And you can see that in the development of the statutes of the ad hoc tribunals for former Yugoslavia and Rwanda. Before the creation of these statutes, the general wisdom, conventional wisdom was there is no international kind of criminal offense of war crimes in non-international armed conflict. There were some kind of dissident voices. Theodore Meron already wrote in the other direction some years before, but he was a quite lonely voice, and all of a sudden this showed up in the statutes of the two ad hoc tribunals on former Yugoslavia and Rwanda, and then it was some years later consolidated in Article 8, Para 2, literacy and E of the Rome Statute, and now it's clear also in non-international armed conflicts. For example, and that's my point, terror attacks against the civilian population and other protected persons are crimes under international law which fall under the universality principle and must be prosecuted by all states, and also if there's jurisdiction by the International Criminal Court. I've only put on the slide here the core paragraph, which kind of mirrors common Article 3 of the Geneva Conventions into war crimes in non-international armed conflict. And it's quite clear if you have these kind of these two little parts downwards, which are the specific elements, it's quite clear that this covers also terrorist tactics. Mm-hmm. There's also litera E also covers that, but I don't want to go too much in detail on that. Which means, as a result of the legal developments of the last 20 years, we have a clear kind of criminalization of terrorist strategies also in non-international armed conflict. Kind of fighters which use terrorist tactics are outlawed as war criminals. And this is not only relevant as far as the ICC has jurisdiction upon criminal acts under the Rome Statute, but it remains also relevant for national prosecution authorities. Germany, for example, has mirrored the Rome Statute crimes into a specific statute, the Völkerstrafgesetzbuch, the code on crimes under international law, and there's a specific responsibility of the federal attorney, the office of the federal prosecutor, the Bundesanwaltschaft, to investigate and prosecute in these cases, and the office of the federal prosecutor has built up a sizable unit for crimes against international law. They are also undertaking at the moment so-called cluster investigations on Syria, where they kind of collect information on the general context. And the background is that it's quite likely that in some time in the next years there were cases coming up of Syrian refugees, migrants, which have come to Germany, which have been involved in war crimes in Syria. It's an experience we made with post-Yugoslavia in the late 90s, that with a big wave of refugees from Bosnia, at a certain time, some victims were detecting, well, the guys which were kind of haunting us, they're also here in Germany, and they were going to the police, and one was starting to investigate. All these proceedings didn't come to an end in Germany because they were transferred to the Yugoslavia tribunal. It were the first cases with which the Yugoslavia tribunal was then going about. But it's quite probable that this will come up in Germany in the next years, and that's why the office of the federal prosecutor is preparing for that. What we have at the moment, that's only at the sideline, are some proceedings against foreign fighters, and it's not only, as I said before, most of them are going simply for being members in a terrorist organization, but there are also some cases for participation in hostilities, cases of members of al-Nusra brigades participating in attacks on other groups or military installations of the Assad regimes, and they are prosecuted, and some are in proceedings, court proceedings now, for joint homicide, for being participating in kind of not justified lethal violence against others. And if that's not only participation in lethal violence, but terrorist attacks against civilians, that would end up as a war crimes trial. Some words on criminal cooperation. Such jurisdiction depends very much on specialized investigation and prosecution units. They depend again on international cooperation, which works relatively well in the context of the EU with all the more recent instruments like European arrest warrant, European investigation order, but it creates still problems in a purely international setup of cooperation in criminal matters. There still are a lot of problems lurking around the corner. So my conclusions. The traditional avenue of judicial cooperation was very cumbersome, and all the international treaties worked out in the UN context on specific modes of terrorism didn't help that much in that regard. In some cases, I would say there are no alternatives for military methods of fighting terrorist groups if they are in safe haven in fragile failed statehood contexts, in situations of non-international armed conflicts. You can do that only by military operations. And the legal framework of law of armed conflict in these cases is helpful. It allows robust use of force, but, and that was my second major argument, it also clearly outlaws terrorist strategies, has built up a kind of international consensus on the kind of heinous character as a crime under international law for these strategies. So I think I stop at that.
We'll have time for question and discussion, but I think that we'll have the 3 papers before. And our next paper is by Stefan Vogt, a principal investigator in the Minerva Center, a professor at the University of Hamburg, and the director of the Institute of Law and Economics, and my oldest colleague, I think.
Probably, yes. Thanks for reminding me that I'm so old, or that we both are so old.
Yeah. We saw
Okay,
the
thanks for having me
generation.
on the program. Actually, I knew that Stefan was going to talk before me, so there's very little definitions, there's very little theory. My value added to the group could be basically an empirical look at some issues, and that's what I'm planning to do. I should point out that this is joint work with Christian Brønskov from Aarhus University in Denmark. Of late, terrorist events have also caused the declaration of states of emergency. Just think of France, it was already mentioned, and it was then sort of basically transformed to permanent legislation last November, but also other countries like Tunisia and Egypt declared a state of emergency subsequent to terrorist incidents. So we want to deal with 2 questions here, namely the first one, what factors determine the declaration of a state of emergency subsequent to terrorist attacks? And the second one, have emergency provisions been effective in dealing with terrorist activities? And there's context. Most of you know the context. Obviously it's due to the Minerva Center, but just 2 words on context beyond that. We've looked at the effectiveness of emergency constitutions with regard to natural disasters. That is a lot easier than looking at terrorism because natural disasters are exogenous events, whereas terrorist incidents are not. So we have a little sort of technical challenge here. This is basically, we're trying to sort of deal with this challenge in this paper. This is the structure of my talk. Actually, I'll be very, very brief on conjectures. Stefan said something about that already. I will then talk a little bit about the estimation approach that we choose to find some results, and then deal with the question. So first question, what factors determine the likelihood of a terrorist attack? Second question, what factors determine if a state of emergency is being declared subsequent to such an attack? And thirdly, have emergency declarations had an effect on repression? So if one thinks of counterterrorism policies, declaring a state of emergency could be one such measure. It could be one measure to basically try to deal with terrorism. And all I want to say here regarding our conjectures is that we expect the likelihood of a declaration of a state of emergency to increase by the number of attacks that take place, by the severity of the attacks that have taken place, but also, and this is sort of what I as an economist bring to the table here, by the costliness of calling a state of emergency, how difficult it is to get the approval of whoever needs to approve, and what are the benefits of calling a state of emergency? Does the state of emergency allow me to search whoever I want to search, or to censor the press, or to dissolve parliament, or whatever? So let's get right into the empirical part. What we need is, or what we use, is three different dependent variables. So one is a variable on did terror occur. So we need some sort of database that tells us whether in a specific year, in a specific country, there has been one or more terrorist incidents. The second question is, if it occurred, did it lead to a state of emergency? So we need information on who declared, what governments declared a state of emergency, and how long did it last? And thirdly, did government repression level change as a consequence thereof? So we need some information on repression levels. And here are the data that we use to answer these questions. Basically, our information on terror events comes from what is called the Global Terrorism Database. That is the most widely used terrorism database around, which covers the period from 1970 to 2016. More than 60,000 events in total are being covered. They originate from 82 different countries, and we basically aggregate them on a yearly basis, giving us something like 3,000, almost 3,600 country years. Second question, we simply take that from our own paper, which is forthcoming, where we have looked at all the states of emergencies that have been declared over the last couple of decades. And finally, repression data, where do we get that from? This is a look at basic human rights, the recognition compliance with basic human rights. This is a fairly modern, fairly recent data set from a political scientist, Chris Ferris, with higher values indicating less violations. It's important to keep that in mind. Higher values mean it's good. Here are the things that we want to control for. Some of you know this because it's part of every talk that I give on emergency powers here. We have a cost ENAP and a benefit ENAP, index of emergency powers, ENAP for short. So in its cost part, we look at how difficult is it to declare. At the benefit part, we ask what are the benefits for a government after declaring a state of emergency. It's coded between 0 and 1. 1 basically means it's really, really nice for government. It has lots of benefits and has zero cost, or has very low cost. Whereas basically 0 means there's no benefits, but also it will be extremely costly. We basically systematically separate the two. We don't put them into one to make things simpler. So in addition here, we introduce a new category, uncertain, which is important because it includes those countries that do not have explicit emergency provisions in their constitution. And you mentioned already some of them. So it's a completely different approach, and it's important to keep that in mind. Some additional information comes from the Global Terrorism Database, how many events in a year, and against whom have they been targeted. So is it against the government, the police, the military, civilians, and so on. We also control for a number of economic issues like income per capita. Has the country been in a recession? but also the size of the country and a couple of political covariates. So form of government, political scientists and economists have been interested in the differences between presidential and parliamentary systems. But obviously another issue would be whether there is a huge difference between democracies and autocracies. So we also look at that. These are a little more, well, exotic, I should say. We have a Hafendahl index of the legislature. The Hafendahl index basically is a concentration measure. It's been used to measure the concentration in industries. But we can also use it and apply it for the legislature. So the question is, how concentrated is the legislature? In other words, how difficult might it be to call the state of emergency if there's like 10 or 12 different parties in parliament? It might be more difficult than if it is just one or two parties. Okay, so that's why we have this Hafendahl measure. And then we also look at the political ideology of the legislature from -1, very traditional socialist, to +1, classical liberal or libertarian, to see whether ideology plays a role in the propensity to declare a state of emergency. In addition, we have a couple of de facto institutional quality variables. We look at the strength of civil society, whether the judiciary is accountable, and whether it's corrupt. This is more details. Well, this is important. I should say that. So the first take that I will give you, this is what the paper is about, is from 79 countries that have more or less a Western-style constitutional democracy type of constitution. I will show you some more estimates for a different group of countries, but our first take was that if we have a fairly homogeneous group, we don't need to control for many other things that we might otherwise need to control for. And then we have fixed effects, both time and place. Okay, now to the estimation approach. What we do is a two-stage Heckman approach. Basically, that means we first estimate the likelihood that a terrorist event will occur in a given year, in a given country. And then the second stage is, given that it has occurred, what is the likelihood that a state of emergency will be declared? Okay? And now, I discussed this for a long time with my co-author. He insists that it's correct and can be done like this. We include our INEP, the index of emergency powers, the cost part and the benefit part, already in the first stage, when we only want to estimate the likelihood that a terrorist event occurs, to alleviate some endogeneity concerns. For example, terrorist events may be more likely if it is more difficult for government to react swiftly. Okay, so if the governments are smart, if the potential terrorists know that, hey, if we commit some sort of terrorist attack, it will be very difficult for the government to react, then we are more likely to commit it. That could be the case, that's why we control for it. And also, the cost unit and the benefit unit, they might reflect previous experiences of the country with terrorist incidents. Okay, so that's why we want to have them in already in the first stage. And also in the first stage, estimating the likelihood of a terrorist event taking place, we also include a dummy for whether government declared a state of emergency in the previous year. So this is interesting. I mean, it's a bit iffy and fuzzy, but it's interesting because it allows some inference whether a state of emergency has helped to reduce the likelihood of future events. Okay, so we look at, has there been a state of emergency in the subsequent year? We still observe terrorist incidents. Then we would have at least some reason to question to what degree the declaration of a state of emergency would have been effective. Okay, so that's the idea. And then in the second set of estimates later on, we ask whether governments react to terrorist threats by increasing repression. So three things basically to look at before we get there. Just a quick look at the descriptive statistics. So this is the data from the Global Terrorism Database. Now you will all ask what is happening in 1993, and that's a really strange story. The organization that runs the Global Terrorism Database, they moved and all the information was in one box for 1 year, and they somehow lost the box. So the data for 1993 are basically most likely lost forever. So this is why you have the strange information here on 1993. Basically, these are all events. So they, if you look at the beginning of the 70s and right now, they haven't really changed that much. What has changed a bit is the declaration, the likelihood of declaring a state of emergency subsequent to a terrorist attack. It doesn't look like it, but basically it has almost doubled the likelihood. And then we look at whether some of the changes are results to the Soviet Union or the demise of the Soviet Union, but that's not the case. So here you go. So this might be hard for some of you, but basically if you don't like numbers, just read this part here. And for those of you who like numbers, don't look at this. Right now we are only concerned with the first stage. Okay, so this is the first stage. So this is the likelihood that a terrorist incident will strike. And the first thing that we know, if we walk through this sort of step by step, is that if a state of emergency had been declared in the previous year, this is highly positively correlated with a higher propensity to experience a terrorist attack in this year. So I don't want to overinterpret this, but it seems to indicate that declaring a state of emergency at least does not dramatically reduce the likelihood of terrorist incidents occurring. Okay. Then log population size, well, larger countries have more terrorist incidents. The half and down here basically is interesting, but if you control for more things, which I don't show you, it vanishes, or the significant vanishes. So ideology basically here means that, remember, -1 was socialist, +1 was liberal. So the higher the value, that is the more right-wing or the more conservative, whatever, more liberal a regime is in the European sense, the less likely a country is to experience a terrorist incident. And then we look at the uncertainty provision. So that's basically countries that do not have constitutionalized emergency provisions. They are somehow, for some reason, less likely to experience terrorist incidents. Benefit, Nina shows us the higher the benefit means, the higher the indicator value means the higher the more benefits for a government, the more likely terrorist incidents are to occur. I don't want to overinterpret this result, but it could be sort of, if I take up the fear story from the keynote this morning, one possible story that one could give is that if government uses measures to suppress people, to take away basic human rights, to repress people, then the information revealing of people who are close to potential terrorists to the police could be lower. Okay, so this could, again, I don't want to overinterpret this, but this seems to be a possibility to interpret that. So that's the likelihood of terrorist incidents occurring. Now to the next question: what factors determine if a state of emergency is declared subsequent to a terrorist attack? And well, now you can basically walk through yourself. The higher the number of incidents, the higher the likelihood of declaring. That's straightforward, just as we expected. Interestingly, if the number of incidents that target government is higher, then this somehow lowers the likelihood of a state of emergency being declared. And then the thing that I wanted to point out, because it was also mentioned in a slightly different context this morning, if we have an election year, other things equal, the likelihood of a state of emergency being declared is lower. So it seems that politicians don't expect the declaration of a state of emergency to be popular. Would be one possible interpretation. A closer look at democracy is only how am I doing on time? Eddie?
Yes.
I have time? Good. So I don't want to talk about this at length. Just here we have the civil society strength. So this is very interesting. So this is again back to the likelihood of a terrorist incident occurring. So what this shows is that the stronger civil society is, the lower is the likelihood of a terrorist incident occurring. So I think that's a nice result. I'll skip this. And well, so this is joint work with a Danish co-author of mine. So I write up the stuff and then he estimates. Okay. So he estimated this for like 79 Western-style countries, and I told him, well, have a look at this map. I mean, aren't we missing the main stuff? I mean, most terrorist incidents obviously occur someplace in the world that is not covered by what we cover. So I told him we have to do this again, well, we said, okay, so what criteria should we use to delineate the countries? So I told him I was going to go to this conference and in the Middle East. So we figured we just look at the member states of the Organization of Islamic Countries. Okay, Israel is still not in. I mean, not in our estimates here. Unfortunately, we couldn't include Afghanistan. Would have been nice, obviously, but some other data for Afghanistan are missing, and the same holds true for these other countries. And actually, I should warn you, this is not as precisely estimated and as the previous stuff, but I thought it would be interesting to still have a look. So the red countries are basically part of what I presented so far, and the yellow countries are those that I will talk about for a minute now. Can you see? I should have done this differently. I'm sorry about that. So interesting. I mean, there are some differences that one observes between Western countries and Muslim countries. What is interesting, what I think is very interesting, is the relevance of coups here, both for terrorist incidents occurring as well as the likelihood of state of emergencies being declared. This is the selection, and this is the state of emergency again. What I sort of think is probably most amazing is that the constitutional rules here at least are very highly and very robustly correlated with both terrorist incidents as well as states of emergency being declared. So I don't want to go into this at all, but it seems to indicate that in that group of countries, constitutions do play an important role too. Now back to the original group of countries with the question: have emergency declarations had an effect on repression? Here we are distinguishing again between all countries and democratic countries. Basically, you can read the results here. More terrorist events are correlated with more repression, more people killed as a consequence of a terrorist attack are correlated with more repression. Military dictators are particularly harsh, and the declaration of the state of emergency is also connected with more repression. So this is, at least in my mind, in no way surprising. But it, as an economist, I say it's always good to know that it's not only in line with our intuitions, but we can. The facts also seem to be in accordance with our intuitions. So this is only a very first look and provisional look at some of the questions. What we would like to do, but it's not as it's easily said, but it's not as easily implemented, are at least two more things. Namely, to ask whether the declaration of a state of emergency and or the passing of additional counterterrorism laws lead to a change in the kind of terrorist incidents. Like after, 9/11 was logistically demanding, right? You need many people to coordinate their behavior. If I look at what's happening in Germany and other countries now, there's one guy who takes out a knife and runs through a train. Okay, so it could be that if you have countries with a high state capacity, it becomes more costly to run logistically challenging operations, and then terrorists switch to very simple, logistically non-challenging types of attacks. Also, what would be interesting, but it's very difficult with the data that we have, is whether terrorists modify their timing as a consequence of declaring a state of emergency. For this, to carry this out, one would obviously need very, very precise data on the exact dates that things occurred, and that is sort of a difficulty. And also, what would be interesting to do is to ask whether declaring a state of emergency and passing counterterrorism laws are basically complements, or they are substitutes. So states do governments do the one or the other, or if they do the one, they are very likely to also do the other. Again, here there are some databases on counterterrorism legislation, but they always only start at some given year, so we can only observe the changes over the last 20 years or so, but we never know sort of the starting point. So what we would need is basically some information on previous counterterrorism laws that have been passed 30, 40, 50 years ago, which we do not have. So this is why we are, we would like to do that, but it's sort of difficult to implement. And I think this is, this is it.
Thank you,
Can
Stefan.
I ask quickly just a clarification question? Or maybe
Oh, sure, yeah, go ahead.
Well, I was wondering whether there was any data on how likely it is, once a state of emergency is declared, for it to then be undeclared or revoked.
That's a very good question.
Or maybe
I mean,
that's
undeclared,
a
you
question
mean it is stopped, right? It's
Yeah.
What?
Undeclared.
Undeclared basically means you say after
Then
like
it
in
lapses, or
Rome
then it's
after 6
revoked.
months it was over,
Right.
right? That's a good question, and obviously you're very interested in that. The problem is that many so you need some data on this, okay? And the way we've been collecting our data is by looking at previous publications, but also by looking at newspapers. We've been the net, and newspapers, blah blah blah. So unfortunately, there's an important asymmetry between reporting on the declaration of a state of emergency and reporting on the end of an emergency. So at times it's very difficult to find exact information on when that is stopped. The question is interesting in a number of contexts. This is one, but there's other contexts in which we've wanting to answer that question, but it's very difficult because the data is very scarce.
I also have some clarification. We'll hear Laila first, and then we open for discussion. So it's really a pleasure to have Laila Margalit with us. At last, someone from the field. Laila is a researcher at the Israeli Democracy Institute, but she worked before at the Association of Civil Rights and had a lot to do with representing cases and people connected to terror activity.
Cases more than people, but
Yeah.
okay. So in June 2016, the Knesset passed the combating terror law, which is an extensive piece of legislation granting the government broad powers, criminal and administrative powers to deal with terrorism. Apropos the question of whether a state of emergency ever ends, before the passage of the law, most of the powers used by the government to deal with terrorism were enshrined, as Ellie mentioned earlier, in emergency legislation and draconian regulations passed down from the British Mandate. And the passage of the law was supposed to be part of, or formed part of, an effort that has been underway over the past few years under pressure from the Supreme Court to finally bring an end to the state of emergency, which has been in effect since 1948. In practice, however, and to create an anti-terror framework that would both be appropriate for the permanent law books and also, as all new legislation in Israel must do, withstand constitutional review, or at least be capable of withstanding constitutional review. In practice, however, as many people have noted, the law that was passed reflects in many respects a normalization of the exceptional rather than substantive reform. Much attention has been given to the broad definitions of terrorism in the law, the exceedingly broad discretion given to the government in how to apply the law, the use of secret evidence in a broad range of proceedings, some punitive rather than preventive in nature, and the powers of administrative detention and control, a portion of the law which is still being discussed in the Knesset but is likely to pass soon, as well as the distortions to substantive and procedural criminal law which the Act introduced. Today, I want to focus specifically, sort of zoom in on a different aspect of the counterterrorism law, which has been the focus of somewhat less discussion, which is the regime that it established for the prescription or designation of terrorist organizations and its potential impact on democracy. My argument, in short, is that while this regime has generally been regarded as one of the few areas in which the combating terror law actually served to improve human rights guarantees, substantively reflecting the non-emergency nature of the law, when viewed in its broader context, it actually demonstrates just how habituated we have become to the types of emergency powers granted to the government under the emergency regime. It reflects truly a remarkable conception of executive power, not just to take limited preventive action to deal with violence and terrorism, but to both shape and constrain democratic discourse and the associational freedoms of citizens well beyond dealing specifically just with violence. Now, obviously, after 9/11, mechanisms for designating terrorist groups and for prescribing terrorist groups became an integral part of the war on terror, both within the international community, the Security Council, the EU, and in democratic countries throughout the world. It's one of the basic pillars, or the most fundamental pillars, of the international regime of cooperation for dealing with terrorist finance. And so, against this backdrop of international consensus and the long practice under Israeli law of prescribing organizations, it's not surprising that the designation regime under the combating terror law was deemed one of its less controversial provisions. It even contained important procedural improvements. So, for example, if under the emergency regime, an executive decision was all that was needed to declare an organization illegal or a terrorist group, and there was no prior notice or hearing, the counterterrorism law establishes a special advisory committee headed by a senior judge. It requires giving warning to domestic terrorist organizations, some domestic organizations, when there is an intent to designate them. A person has a chance to challenge, which is actually unusual in the comparative international arena. There's an actual opportunity to challenge the designation before it becomes final, so it's not a hearing only after the fact, but it happens beforehand. But what was striking was that throughout the more than 30 hearings that were conducted in the Knesset on the law, which were characterized both by supporters of the law and by people who, both by supporters and detractors of the law, as uniquely serious and in-depth. There were really marathon meetings in the Knesset that were much more serious than what is usually expected. The danger that the prescription process itself would pose a danger to democracy or to freedom of expression and freedom of association wasn't really taken seriously. A lot more attention was focused on the concrete harms that prescription could cause to specific individuals or organizations as a result of a specific designation. The third parties who might be harmed, or innocent groups that may be caught up in a broad regime. And I think, to a large degree, there was a sense that the debate over prescription is over, that it has been recognized as an essential and fundamental tool in the war on terror, and it's something which is accepted throughout the democratic world. And so even if there is no process which is ideal, and even if there are costs associated with the process, it's something which is legitimate and essential. But what I want to argue is that a more in-depth look at prescription regimes around the world show that they don't all pose the same risk to democracy. And I want to suggest, it's also a work in progress, a framework for evaluating prescription regimes and the risk that they pose not only to individuals but to free democratic discourse based on 4 basic parameters. Different regimes around the world strike different balances with regard to each one of the parameters, but you can't really evaluate the impact of a regime without taking all of them into account. So the first parameter relates to the scope of designation, the consequences and implications, how the designation or the impact that the designation has in the world. And I suggest sort of mapping them out on 2 sides of a spectrum between regimes that can be characterized as instrumental, where they're more limited in scope, they're more preventive in nature, they're targeted specifically at the financial resources of the organization. They don't make the organization illegal per se. They don't prohibit membership unless the membership is connected to some intent to further the violent aims of the terrorist group. There's no prohibition on independent expression of support or identification with the group. So it doesn't become illegal in a deep sense. And on the other side of the spectrum, regimes that can be characterized as, I call it essentialist, I'm not sure that's the best term, but regimes which render the organization illegal in a deep sense, prohibitions on membership regardless of intent, prohibitions on discourse surrounding the organization, broad scope, allowing prosecution for a broad range of offenses simply based on the connection to the group and simply based on the connection to the group because it has been designated. So that's the first parameter. The second parameter has to do with fairness and transparency, ranging from what could be characterized as a strong process to a weak process. A strong process with a meaningful opportunity to contest the designation, the right to be notified of reasons, strong mechanisms, and this is probably the most important point, for handling any use of secret evidence, the use, for example, of special advocates or cleared counsel to review the evidence, and a guaranteed summary of the allegations against the entity, periodic review, judicial review, and in some cases parliamentary review. And on the other side, a weak process, no hearing, broad reliance on secret evidence, etc. The third one has to do with the application of the regime, domestic application or not. Is it targeted primarily at foreign groups and viewed primarily as a foreign policy tool similar to the imposition of sanctions on foreign governments? Or is it viewed as something that can be used domestically as well without distinction? And obviously human rights law in general is loath to recognize distinctions between law applied to citizens and law applied abroad. Obviously there's a serious issue of discrimination, but I think specifically with regard to the issue of application, specifically with regard to the issue of designating terrorist organizations, there is a relevant basis for distinction. Obviously, when a domestic political group is targeted, it's not just the group's assets that are at stake. There's a danger of repressive restrictions on the limits of democratic discourse within the polity, which isn't relevant to international organizations to the same degree. And the fourth criteria or parameter has to do with the criteria for designation. Is it targeted just at violent groups? Or if not just at violent groups, at least at groups that that contribute in some material way to the violent activities of other groups? I would put in that category organizations which fund violent terrorist groups, even if they don't actually participate themselves in terrorism. Or on the very other side of the spectrum, what you were talking about in Russia, subversive groups, organizations that are merely, for example, associated with designated groups, even if they don't provide support that could further their terrorist aims, or even groups that are targeted based on their political agenda. So I'm just going to give a couple examples, and then I want to come back to talk briefly about the counterterrorism law. So Canada is an example, a good example of a designation regime that is carefully instrumentalist in nature. Outright banning of groups and criminalization of membership, which in the 1970s had led to the imprisonment of Quebec separatist sympathizers, would be considered today against the Canadian Charter. So when an organization is listed, it doesn't make the group illegal, and it doesn't prevent people from expressing support of it or being members of it. The direct implications are tied to the finances of the group, and the offense of participation or activity within a terrorist group is limited to participation for the purpose of enhancing the ability of the terrorist group to facilitate or carry out terroristic activity. And the Supreme Court in Canada has clarified that it excludes conduct that a reasonable person would not view as materially enhancing the ability of the organization to facilitate terrorism. The process, on the other hand, is a relatively weak one, although the constitutionality of the process hasn't been tested. There's no prior notice or hearing. Groups can apply for delisting, and there is judicial review, but there can be reliance on secret evidence, and the statute doesn't specify any means for dealing with the secret evidence. Although given Canadian constitutional law, there's a reasonable chance that if it did reach the courts or the Supreme Court, that something like a special advocate could be mandated. Substantively, the kinds of organizations that can be targeted, similarly to the counterterrorism law in Israel, it allows for the designation not just of groups engaged in terrorism itself, but groups that act in association with terrorist groups. So that's broader. Quickly, the United States. I don't want to get into all the details, but there are two main regimes for declaring organizations in the United States: the Foreign Terrorist Organization Scheme run by the State Department, and the specially designated Global Terrorist Scheme run by the State Department and the Office of Foreign Asset Control of the Treasury. Significantly, both regimes are targeted primarily at foreign groups. The Foreign Terrorist Organization can only be a foreign group. But the special designated global terrorist regime can be and has relatively infrequently been applied to domestic groups, but only because of or only on the basis of ties with foreign terrorist groups. Like in Canada, the primary implications are financial. There is a broad prohibition on material support to foreign terrorist organizations, which in a very well-known judgment of the American Supreme Court was interpreted quite broadly to include material support even if it does not further the terroristic, even if it does not further the terroristic aims of the group, even as in that specific case, providing training on international humanitarian law to groups that have been designated can be considered a violation of the statute. However, and this is significant, the court took pains to emphasize that the broad prohibition on material support would not be likely applicable to domestic groups that have been designated. So for example, if a domestic group is designated, it would be considered unconstitutional to prohibit speech activities in conjunction with that group. And at the same time, membership itself is not an offense. Following the McCarthy era rulings of the Supreme Court clarified that you need to have intent to further the criminal or violent aims of the group in order to criminalize membership. And unsurprisingly, in the United States, although there's no offense of expressing support for a terrorist group unless it's being done in conjunction and coordination with the group. In terms of process, the statutory processes are quite weak, but courts have recognized due process guarantees for organizations that have U.S. ties. And with regard specifically to the issue of secret evidence, courts have grappled with the issue of secret evidence and have explored different means for dealing with that, for example, requiring a summary or allowing counsel with security clearance to access the material and review it, even if they can't then discuss it with their client. And again, here the criteria substantively are quite broad. It includes terrorist groups and also groups that are otherwise associated with designated individuals or entities, so substantively it's broad. With regard to both, so I mean, you can see that with regard to both Canada and the United States, if you zero in on any one of the parameters, some of them are quite extreme, but they tend to compensate for one another. If you can't designate a domestic group in the United States based on its domestic political agenda or based on or based on its domestic activities that are not connected to a foreign terrorist group, the ability to use it as a tool of political repression is obviously much less. And if membership and association in and of themselves are not criminalized, the implications of a mistaken designation based on weak process for political freedom and democratic discourse are far less. So now back to Israel, the Combating Terror Act. I think it can be characterized as essentialist on steroids, in the sense that there's a broad prohibition on membership and participation, including purely passive membership, with no need for a nexus between the activity and any terrorist or illegal activity of the group. There's a broad prohibition on expression of support. So, for example, I can find it. It's an offense carrying a punishment of up to 3 years to commit an act of identification with a terrorist organization, including by publishing praise or support, raising a flag, etc., and doing so in public with the purpose of, not with the purpose of promoting the illegal actions of the group, but for the purpose of identifying with the group. So there is a requirement of intent, but the intent isn't to contribute to the group's illegal activities, but rather to identify with the group in and of itself as an illegal intent. A broad prohibition on material support, seizure and confiscation of assets like other designation regimes, police power to preemptively shut down rallies and meetings even before they've taken place, which is a really, I mean, this is prior restraint of the right to meet and to have rallies, not based on anything substantive that's happening in the rally at that moment, but based on the very fact that an organization was designated. The designation itself has weight beyond any allegations regarding what's taking place at the meeting. Police power to shutter institutions or buildings used by the organization, and in addition, being active in a terrorist organization, being active in an organization that has been designated as a terrorist organization, in and of itself allows the use of draconian detention and interrogation rules. For example, the right to prevent a suspect from meeting an attorney for up to 21 days, from the very fact that they are accused of being active in an organization that has been designated, full stop. So that's another consequence. The process, like I said, is mixed. It's far improved. It's far better than the process which existed previously. There is a right to a hearing before the designation becomes final. The issue of secret evidence, there's a balancing test in the law which requires the advisory committee not just to determine whether the information may pose a risk to security. It's not enough that it be classified. The committee actually has to balance that against the need to reveal the information in order to allow for a just result, which is a very important balancing test, which I think doesn't always exist in other designation regimes. On the other hand, there's no clear counsel or special advocate, and there's no guaranteed summary, although the law does state that as far as possible, a summary has to be provided to the detainee. Just as a side note, let's say in the UK, which might be a less comfortable example for my argument, because there it's a much more essentialist approach to the designation and its consequences, a special advocate is appointed for the designation proceeding if it's challenged in court. And here also, the advisory committee hears everything in closed chambers in camera, and the proceedings are considered by default to be classified unless the committee rules to allow them to be published. Okay, and then obviously the application is domestic and foreign. And another point in terms of the substance and the danger that it could be applied to subversive and not just groups engaged in violence like Canada and the United States. Substantively, it can be applied not only to organizations that engage in terror, but organizations that are associated with organizations engaged in terror. But there's another point, which is that the Combating Terror Law adopts all the designations that had been made ever according to the emergency legislation, to the emergency regime which was in place beforehand. So for example, and I think this is a particularly salient example of the type of danger to democratic discourse that such a regime can present, the northern branch of the Islamic movement, which was declared an illegal organization according to the defense regulations in 1915, and is now a terrorist group for all intents and purposes without any need for review. And if you look at the arguments which were put forth, or the summary of reasons put forth by the government, there was a press release on the day that they were designated, right after the horrific attacks in Paris. There are some vague allegations of collaborating with Hamas and being a sister organization of Hamas without explaining what exactly that means. But the more specific accusations are actually quite striking. So for example, it says that the northern branch of the Islamic movement conducted a false campaign of Al-Aqsa being in danger in order to, and this is in bold, in order to accuse the Israeli government of untrue accusations regarding an attempt to harm Al-Aqsa and to break the status quo. That's a political reason. One of the reasons is also that it's an isolationist, extremist, racist organization which does not recognize the state authority, which does not recognize the right of the state to exist, and which wants to establish a caliphate instead of the state. One can think of other political parties in Israel that don't recognize Israeli democracy from all kinds of directions. And importantly, the issue of whether the Islamic movement, and I'm not trying to argue whether it should or should not have been designated as a terrorist organization, as a illegal organization, and now as a terrorist organization, but there was no information put forth that says explicitly and clearly that the Islamic movement ever did anything to actually further terrorism, even if they accept funds, for example, from charities which also fund Hamas and they're associated with Hamas in some way. The government was never forced to put forth a case that that it's involved in actual terrorism. That's it. Yeah, I'm done.
2 minutes. Yeah.
That's okay. Let me see. Yeah, I think that's it.
Thank you very much. We open the floor for comments, questions.
I would like to put the question to Stefan Wilczek. If I understood you correctly, then terrorists are under obligation to respect, or let me say, to spare the lives of civilians, both under traditional military use in bello, so Geneva Convention, and under the Rome Statute. The question is, does that mean that they are combatants? And if this is so, or if it comes near to that, this comes back to our dispute which we had in the break about the distinction between war and terrorism. So whether the status of terrorists comes closer to the status of military combatant, with consequences, of course, with respect to which kinds of measures, weapons, and so forth can be applied. Just a follow-up question, which is a very small one. What then is the status of an enemy combatant, category which the United States have created for the Guantanamo prisoners? So
Unlawful combatant.
Well, I mean, unlawful. I mean, doesn't that have a structural meaning insofar as they try to kind of distance the terrorists from the military combatant? If international law, as I said in my first part of my question, closes the distance between the two, so they try to return to the old distance between terrorists as a criminal on one hand and a military combatant on the other. So could you just clarify the conceptual situation of this status regime?
Well, the conflict situation I was talking about were practically all non-international armed conflict situations, and the regime, and there's a kind of radical difference between traditional international armed conflict, where we have all these rules on combatant status, combatant privilege, and so on, and the non-international armed conflict where this doesn't exist. There was an attempt of the ICRC in the Geneva Diplomatic Conference in the 70s to assimilate, in that regard, the two regimes. There was a kind of more or less uniform resistance of states towards that attempt, which means in non-international armed conflict there is no special status for fighters. They may be prosecuted for participating in the armed conflict because they are not. There is no rule, a kind of no equivalent to the combatant privilege, saying since they fulfill a fighter function, they are at least justified in using armed force against the enemy. A state may prosecute insurgents. That's the background why states were so much against it, because they wanted to retain the possibility of prosecuting for insurgents for taking up arms against the state organs. Which means there is no combatant status in non-international armed conflict. And that one, in a way, leads to that Guantanamo-linked figure of unlawful combatant, which is an old concept. It stems from the old ex parte Quirin case of the 40s in the United States, which were kind of German saboteurs brought to the U.S. Acting in civilian clothes, trying to commit a kind of assaults on United States territory, soon captured and then prosecuted as kind of ordinary criminals. The problem with that unlawful combatant is that since there's no combatant status, fighters in principle in a non-international armed conflict are civilians, and they fall under the protective rules for civilians. They might be prosecuted for their armed activities, but they have the procedural guarantees of civilians. This is part of the struggle why the Supreme Court finally declared at least common Article 3 applicable to that, which also means there are some at least minimum guarantees for that. But there is no special status, and the interesting thing is, but they are, like combatants, legitimate military targets. But that's the kind of alternative figure of direct participation in hostilities, which means everybody who is actively participating in armed hostilities may be attacked. That's in a way parallel to the combatant status, but without the kind of protective guarantees of the combatant status in an international armed conflict. In a way, we have a very blurred, in non-international armed conflict, a very blurred legal situation by that anyway, because it's blurring between armed conflict and the criminal paradigm. Because they are fighters to a certain degree under law of armed conflict rules, because they are at the same time criminals prosecuted under criminal law.
Just to add the local perspective, there was a very interesting Supreme Court case in Israel, I think 2 decades ago, when Hezbollah people were captured and held under administrative detention, or held in detention, and the Supreme Court ordered to release them because they are on one side non-combatants, and on the other side administrative detention doesn't apply to them because it's only preventive. And the consequence was that the Knesset passed unlawful competence law, which enables the detention of illegal unlawful combatants who are not members of an army in a context of an armed conflict.
Yeah, but just one remark.
Yeah.
It was the case I mentioned. That's also why there are 2 or 3 cases now where foreign fighters which have returned to Germany are now prosecuted in a way, as ordinary criminals due to their participating in fighting in Syria, because they are not legitimated in using armed force against others. And so when they participate in a military attack, they are participating in a joint homicide against
but they enjoy all the privileges of a criminal.
Yeah, no, it's a normal criminal procedure, so it's under procedural guarantees of human rights. It's, but in terms of criminal law, it's a kind of it's also a consequence of that fighters in non-international armed conflicts have no legal legitimacy, no legal justification for using armed force.
Okay, I have a short clarification question for Stefan. I was wondering whether you considered all states of emergency to be identical in terms of the political process that underlies them and the legal consequences and implications, or somehow controlled or considered controlling for the pre-declaration process and the post-declaration legal implications.
And I will add to this question another clarification question. Did you manage to clear the state of emergency that were declared for other reasons, natural disasters, for example, or and additional question? You know, you mentioned the fact that during electoral years or towards electoral years, less declaration of emergency were made. On the other side, one should, you know, intuitively think that terrorists would operate exactly on these periods because they want to influence the election results. And how does this two results, or one intuition and a result, how can you explain that?
Yeah, thanks for the questions. Should I take
Yeah,
it?
not that one.
Okay, good enough. Yeah, it would be really nice to be able to look at the exact nature and the history consequences of all this. No, we basically look at, was the state of emergency declared, yes or no? So it's very simple. We try to take the history into account by lagging a couple of variables. So, for example, when we look at the repression levels, we look at, we have the dependent variable twice lagged. In other words, the dependent variable here is the repression level after the state of, imagine the state of emergency was declared in, say, 2000. We look at the repression level in 2001, but we also have as an explanatory variable the repression level of 1999. So the repression level doesn't come out of nowhere, but we try to take into account the pre-terrorist incident repression level. Okay, so that's taking into account the history of the country in a sense. Did we control for natural disasters? Yes, we did. Well, you don't remember them now, but we do have natural disasters as a control. They do pop up as highly significant, but that gives us the possibility to say we control for them. So, okay. Election years. Yeah, there is an interesting study by Martin Gassegner and Simon Wichinger, who have this paper, One Strike and You Are Out, which basically shows that if one terrorist incident occurs in a country, the likelihood that the government will be voted out of office is very high, is significantly higher than will be the case otherwise. So that's something I can say there. Maybe if you want some sort of normative addition to this, my hunch why constitutions could be very important in dealing with counter-terror, in dealing with terrorist attacks, would be that my hunch is that as a consequence of an attack, many people want the government to act. Many people feel we have to do something now, and I think so. One sort of normative implication could be if we know that the likelihood of
reducing terrorist incidents by doing whatever, by declaring a state of emergency, also by passing additional counterterrorism laws is low. So in other words, these policies are not effective. Then it might be a good thing to make the declaration of an emergency more costly. Basically, to prevent politicians from following the demand of voters that they want to follow, not necessarily because they believe that it will be effective, but because they want to be re-elected. So I think there is an important role for constitutions in dealing with terrorism.
Perhaps one additional question. I was a bit struck between this kind of relationship between declaring states of emergency and the level of terrorist violence. And my intuition is that there might be some kind of heterogeneity problems that kind of in the path dependency of institutional systems, there might be a likelihood of making it easy to declare states of emergency and creating high benefits for states of emergency in societies with a high level of societal violence. So in that sense, that there might be an underlying correlation already in the for structural reasons between what you term the in-app indicators on the one hand and the kind of and the level of terrorist violence in general.
Yeah, but that is exactly the reason why we already included the in-app indicators in the first stage. That was exactly the reason to basically try to take care of endogeneity as well as possible. That's exactly why.
Omer?
I have two questions. My first question is to Professor Stefan Holker. I'm sorry if I pronounced it wrong.
No, it's okay. It's a very Germanic name.
You talked about these two ways to fight the terror, the military and the law, and I thought about Europe, because in Europe right now there's a terrorism that grew up, and the law can fight terror, but it's failed. So from my perspective, when I see a lot of neighborhoods that police force and the performance force doesn't even get in. So in this perspective, it's pretty criticizes this model that the law maybe can take over the military in some cases. And to Stefan Voigt, I'm sorry again.
No worries.
I want to say that if I get the map right, I saw a correlate between the area that the terror is most significant and corruption, if I can say it. This is what I thought.
First, well, I can use that one. If I'm talking on Europe, let's say I'm talking on the criminal law paradigm because it's quite clear the military track, that's for operations abroad to deny transnational terrorist organizations kind of safe haven, and whereas inside societies, I think in Europe that's largely out of question, that you cannot use military means against terrorism. There might be severe situations. We've had that in Europe, Northern Ireland, in the 70s, 80s, where the British had felt the need to make use of the military in going against terrorism. But that's an unusual situation. It's simply the criminal prosecution track and intelligence. And I'm not so sure that whether Europe has failed. I would say in most European societies, and that's even more the intelligence part. There's a steep learning curve in the last years, and they have become better and better in preventing terrorist assaults. There have been some misfortunes. I mentioned this kind of Berlin case, and clearly Belgium, France have a specific problem because they have these kind of ghetto-type environments having gone out of bounds. We have, at a lower degree, also problems like that, but they fortunately have nothing to do with terrorism. That's for us mostly an organized crime problem. We have some quarters in some bigger German cities where we have some these kind of Lebanese. It's not the Kurdish clans, the Muammar Kurdish clans, which are more or less impenetrable for the police and intelligence services, and they have created kind of a kind of no-go areas where they do all their criminal activities, and that has been a problem which has come very much to the surface in the last years as a kind of side issue to the fight against terrorism, where the state now starts doing more against. But fortunately, this is a pure organized crime issue, has nothing to do with terrorism at the moment. And I would say that the balance in Europe, except the French-Belgian cases, it's not so depressing. I think it's a relatively low level of terrorism where societies can live with, and I still would say what we heard in the discourse by Ami Ayalon, still European societies are not so fearful because it's, let's say that the statistical risk of being victim of a terrorist incident is so low that it's not really a daily life issue. And in that sense, I would not be so bad, or so would have such a bad perspective on it. There are still problems. There's still a lot to be done, but I think the reaction in the last years, I would say there is a steep learning curve.
Okay, now I'm not sure that I entirely understood your question. Are you saying there's something that's missing, or?
No, it's not question. It's something that a point of view of the map. Because if you see the spots that there is no terror, it wasn't maybe so much clear. You can see that there is a correlation with the corruption, if I get it right.
Okay.
It's very interesting.
No, okay, yeah. One might want to have a closer look at that. We didn't do it, but there is a paper, again by Martin Gassegner and Simon Lüchinger, who have run an extreme bounds analysis of determinants of terrorism. So basically what they do is they look at all potential determinants that were ever mentioned in the literature and try to see how robust they are, running millions of regressions, okay? And actually we have the most significant ones of those. Actually it's quite a high number. I think it's like 24 or 25 that they find are robustly correlated with terrorism. And we have most of them in here regarding corruption. At least sort of one additional idea or one problem could be, I mean, I'm ready to look at it, but one issue with corruption is it's also highly time invariant, right? So how would you explain changes in terrorist activities over time if you want to have corruption as one determinant? So it's a sort of tricky issue. But thanks anyways.
Let's see.
Oh, thank you. So I'd like to ask Lila and Margarita a question, but it's because of the perspective that Stefan is giving me. And you're arguing for a more nuanced view of a designation of a terrorist organization, which seems persuasive to me. But and it's kind of building on that question as well, how much influence, how receptive is that type of argument in a place like Israel versus another place, say, like the United States, where there isn't as high a level of terrorist activity? So looking at just kind of overplaying what you've done and imposing it on what you're working on. It's a fascinating project.
Follow-up question. I read the new counterterrorism law, and I thought that the last point to be criticized is actually the procedure for declaring an organization as a terror organization, which is, with this pre-emptive or warning and a committee headed by a judge. And So on the grounds, besides the Northern Islamic movement, which was declared before,
right.
Okay?
Well, the government is now arguing in court that it could have been declared as
okay, but besides that, were there any other organizations that were declared terror organization according to the new law, and you think that this was not justified and manipulation of political powers or whatever?
I think it's early to say, well, so two things.
Yeah.
Yeah, so first, with regard to your question, what was interesting about the designation of the Islamic movement was that the Israel Security Agency actually opposed the designation, arguing that it would make it more difficult to track the activities of the movement, and so that there were actually compelling security reasons why not to designate the organization. And it really, I think it was more of a political move. It came from the political echelons, and it actually led to a really interesting half-joking discussion in the Knesset during one of the hearings where some of the politicians said we have to take this power, because according to the law now, first the ISA has to request a designation, then it goes to the defense minister and then to the advisory committee. And they joked, well, we don't want the ISA to do it, you know, they're just a whole bunch. We don't want to leave them with the only authority to determine when an organization should be designated. So I think that security considerations here can pull in different directions. I agree that, and following with your point, I agree that I don't agree that it's the least problematic aspect of the law for the simple reason that, first of all, I think it's early to see how the law will be implemented with regard to domestic groups. I don't think there are a whole lot of domestic groups in Israel that would be at least immediately targeted for the law, but by the law. But I think looking back at the four parameters, even though the process is relatively better than what was before, as long as there isn't an effective method for dealing with the question of secret evidence, I think the danger of and I don't even pretend to know whether there is significant evidence linking the Islamic movement to terrorism or not. But the very fact that linking the lack of an effective way of dealing with secret evidence with the applicability to domestic groups and the substantive definition, which in the law remains broad, together with the essentialist consequences, I think does pose a significant risk. And I think it expresses a theory of executive power that really is remarkable, because what we're basically saying is that the executive has the power not just to take targeted measures, but to do something which ultimately is punitive, because in court you can't challenge the designation. You can only challenge the designation by before the advisory committee. But if you're then somebody who provided services to the Islamic movement, and now you're being challenged, you're being tried for material support, you can't challenge the basis of the designation. There's really no, and that's not uncommon. There are a lot of jurisdictions where that's the case. But I think, and that's why I suggest looking at all the parameters together and not just isolating the process.
Yeah, but perhaps one comparative remark. I would guess that most continental European states follow the essentialist pattern with relatively weak procedures, except judicial review. And there's a relatively broad judicial review on these issues on a common European frame. It's also the Council who can designate terrorist organizations. And there has been a constant struggle between the People's Mujahideen of Iran against the Council. They have several times won at the European Court of Justice against the Council declaring null and void the declaration as terrorist organization of them. In Germany, it has been historically mostly an organization, a tool against PKK and its kind of surrounding organization. Now has become a tool against Islamist organizations recruiting foreign fighters for ISIL and Nusra brigades.
I think our time is done. Okay, two very short questions. and we will shorten the coffee break.
My question is to you. So I'm exempt from the pronunciation. What you have described here is a econometric model, actually, and what amazed me is that I think, maybe I'm mistaken, that you have combined casualty, I mean terror attacks from the outside and from the inside. Now, if this is the case, and I understand that this is the case, I don't understand the questions of the correlation between SOE and an outside terrorist attack. This attack. What is the correlation?
Yeah.
My question also is also addressed to
Stefan.
No, Charles.
Maybe to that as well. Regarding the nature of emergency, or the state of emergency, one of your previous remarks in response to Eli and Ronen exposed or brought to surface a covert assumption of identity, or at least a complete overlap between declaration and a real substantive state of emergency, which is not trivial at all. I mean, it also has to do with the question whether a state of emergency is purely a political question, political in the narrow sense, or is it a legal question? If it is a legal question that you can examine substantively, I'm not sure where it takes your analysis and conclusions.
I think Israel in that respect is exceptional, that the Supreme Court is willing to review the actual declaration of emergency and whether it was for the right purposes. But, okay, go ahead.
I'll try to be quick. So yes, domestic international would be nice to separate. Unfortunately, the global terrorism database doesn't allow this. There's another database that would allow that. It's very complicated to divide the two or to merge the two. So that's clearly desiderata, but I'm not sure that I see the point. I mean, the point is, if I may respond, that you had, if you think of the attacks in Paris in November 14, they were to a large extent committed by people from Belgium. So what is the issue?
The issue is that if you take, for instance, a terrorist attack by let's say the Hamas, how can an SOE impact on the terrorist attack of Hamas?
Well, the idea is that well, let me try to give you a simple answer. If the state of emergency makes the committing of terrorist incidents more difficult, it doesn't really matter whether the perpetrator originates from the domestic country or from a foreign country. It would be more difficult to commit it here if controls are sharper here, if civil rights are reduced here, etc. At least that would be my prior.
In Israel, for instance, the state of emergency, it's insignificant. The level of security is very high, and still we suffer from terrorist attack. And they are indifferent if there is an SOE or there is no SOE. So how can we correlate between everything?
Well, Israel is not in that. I mean, as most everybody knows in the room, Israel has been under a state of emergency ever since its founding. So it's very difficult to compare what the number of incidents would be had it not been under a state of emergency.
Do you think that the consideration of the Hamas or the Fatah or whatever, they are influenced by the state of emergency, or they are ideologically motivated, and that's it? No correlation between the two.
No, well,
okay, please continue over the break. A short reply to Nadav.
No, I mean, let me just cite one paper that was already cited by Stefan Oetter, the Sandra et al. Piece, where they ask whether it makes sense to consider a terrorist as rational actors, whether terrorists react rationally to an increase in costs or a decrease in costs. And actually they showed some of the things that we would like to do for the US. The timing changes, the type of attack changes, etc. So they do react very rationally to change in their constraints. And we'll do this over coffee.
I think this is also the reply to Nadav, that sometimes a declaration of emergency is a political act to protect the regime and not really to fight terrorism.
Sure, definitely.
But thank you very much. It was really a fascinating panel. 5 minutes, 7 minutes.